Bruce, you must have something really good too.
Of course I do. It's Bruce Danielson, and I guess I'm here to entertain you too.
This meeting of the Sioux Falls Charter Revision Commission will come to order. The minutes from our meeting of July 18, 2019 need to be approved as our first item on the agenda. I would entertain a motion to that effect.
So moved, Mr. Chair.
I'll second.
It's been moved by Mr. Zylstra, seconded by Ms. Politas to approve the minutes of our July 18 meeting. Is there any discussion, or otherwise we will move to vote? All those in favor?
Aye.
Any opposed? Motion carries. Those minutes are so approved. Moving to item 3 on the agenda, old business. Item A under old business, public input, time limits and the placement of items on the agenda under new business.
Mr. Chair,
Hayek?
thank you. I did request this because our last meeting, very good information. However, as I looked at how we first of all place items on an agenda, my experience has been legislative committees, various committees that I've served on, that it must be a specific issue that we would deal with. Last month, or last meeting, we had 3 individuals. Mr. Kirby was appropriately on the agenda with specific items, specific changes that we would look at. Mr. Cunningham, although very good, his information was for public discussion in my mind because it was just kind of open, different forms of government, as was Ms. Breckies, who said she didn't have anything specific, but she just wanted to talk. So I know that the chair sets the agenda. I would like to see, because as I've looked at agenda setting policies, one of the big issues is having the information ahead of time for the public and for us as a committee to be able to review and know. And it's really noticed to the public. And for us to consider something in new business, it should be duly noticed to the public. So I believe it would be appropriate for them to come in ahead of time, have specific items that they want to address, and then have any supporting information available for us and for the public to view. So that would be my first issue, and I would make that motion. That they come with a specific item to be addressed, such as Charter Item 4A sub B, or even new to be put in, but a specific change rather than just a general comments, and that they provide any documentary, evidentiary material to us and to the public, so it would be on the website ahead of time, and that that notice be a full week in advance.
So Ms. Hayek, let me see if I understand the motion on which we're going to vote. It would be that if someone wants to be put on the agenda of the Charter Revision Commission under new business, they come forward with a specific proposal in writing, and that they have the materials to the city clerk or to the chair or the city attorney's office at least 1 week before the upcoming meeting where that item will be discussed, and have all the materials there so that they can be reviewed by the public as part of the agenda online for the public then to be able to comment on them at the next meeting.
That is correct. And part of that too, if I will just add, if the public is aware of it, they can also come and be part of our meeting and give us additional information. Thank you. So that's my motion.
We have a motion from Ms. Hayek to that effect. Is there a second?
I'll second.
Seconded by Ms. Politas. Is there discussion on the motion?
Mr. Chair,
Mr. Zylstra.
do I understand that this motion relates to items placed on the agenda under new business? Does not impact public input section of the agenda.
That would be correct.
Thank you.
Further discussion or questions? I would note on this particular item, this is important because any items that are considered under our new business on the agenda would not be subject to any time limits that would be placed on public input. So if someone came forward with a specific agenda item, was on the agenda under new business, they would not be subject to 5-minute time limits or otherwise. We would do them the courtesy of allowing them to have more time. And I think, I will vote in favor of Ms. Hayek's motion, because I think it's important that that if those people are going to come forward with items and we're going to give them the courtesy of having an unlimited amount of time, in order for more transparency and openness to the public in advance of the meeting, we ask that they submit those materials in advance and give enough detail on their proposal that will be discussed at the meeting, that the public will have the opportunity to know in advance, oh, okay, this is something on which I want to come forward and make sure I'm here for that meeting so that I can offer any input at that time and be part of the discussion. Does that all jive, Ms. Hayek?
Yes, it does. Thank you.
Mr. Zalstra?
Well, Mr. Chairman, I like this idea, and especially if the public is aware that they can request to be on the agenda, and that if they do have a specific proposal, the limitations of public input are not applied to them. And so I see this as a step forward in transparency and in inviting public involvement in our discussions. I just hope that somehow we can get that through to people, that they can make a specific request to be on the agenda with a specific proposal, and they will be heard and given due consideration.
Mr. Chair?
Ms. Hayek?
And I would just comment, Mr. Kirby did it appropriately and understood that. He had it to us in advance, specific items, had all the time that he needed to present. And that is the kind of presentation I think that we should request and require here. Thank you.
I would concur. Further discussion? The motion before us is Ms. Hayek's motion that we allow members of the public to request to be items on the agenda under new business, subject to the requirement that they get their materials to the chair and city attorney's office at least 7 days before the meeting at which they will make their presentation. We have a motion to second, and then all those in favor will please vote aye.
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 Any opposed? Motion carries. Ms. Hayek.
The other portion I had is the public discussion. And I understand that the policy had been previously to limit that to 5 minutes, which makes a lot of sense. And I did not understand that till last meeting, but if we have items on our agenda, we are not elected officials, we are appointed officials charged with a specific task. And to go through the material, I believe public comment is certainly appropriate, but a 5-minute limit would be my recommendation. I'd make that motion.
Motion by Ms. Hayek to limit public input to 5 minutes per speaker. Is there a second?
I'll put a second there, but
Mr. Timian, seconds.
my understanding that those are the rules we've been operating under for some time, that under public input was 5 minutes, so maybe it wasn't as formalized as it should have been.
For clarification purposes, Mr. Timian, the Sioux Falls City Council has a rule in effect, perhaps by ordinance, that public input shall be limited to 5 minutes per person. At our first meeting, this session, the commission voted not to put in place time limits for the public input, subject to the chair's ability to end that public input if it was abused or got off topic. So this would be this motion would limit public input per speaker to 5 minutes, similar to or the same as the Sioux Falls City Council.
Thank you for that clarification.
Mr.
But
Chair.
it is not limited if they are on the agenda.
Right.
Correct. Thank you.
Correct. Mr. Koistra.
Sorry. The city council policy, which is an ordinance, is that public input's limited to 3 minutes per speaker with a maximum period of time of 30 minutes. So other boards and commissions have used 5 minutes and typically do. State law has great flexibility as long as there's some period. But just to make sure the commission's aware, it's 3 minutes for city council.
in light of that information, I would make an amendment to my motion that we would follow the rules that the city council has in place, which would be a 3-minute limitation with it no longer than 30 minutes for the full period of open discussion. And I make that change, and thank you for the awareness of it, because the people that come in front of us are familiar with those rules. Those are the rules that they go by, and so I think it makes a lot of sense to be consistent. So I would make that amendment, and hope I get a second.
My second will apply towards that amendment.
There has been a motion by Ms. Hayek that we limit public input for the Charter Revision Commission to 3 minutes per individual citizen, with a maximum of 30 minutes total for all public input. Is there further discussion on that motion? Hearing none, all those in favor of the motion will vote aye.
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 Any opposed? Motion carries. Anything further under item 3A, public input? Hearing none, we will move to old business item B, Charter Article 8, Charter Amendment Section 8.01D, Proposal of Amendment. This item has come forward, I believe, because of some of the recent issues that have arisen with a citizen petition that proposes to put onto the ballot in an upcoming Sioux Falls City election amendments in several respects to the Sioux Falls City Charter. Issues that surround this petition include the number of qualified voters who are permitted to circulate the petition, the consistency between our local municipal petition signature requirements and state law petition signature requirements, and several other issues under that, all of which arise under 8.01D of the Sioux Falls City Charter. Is there discussion on that item? Mr. Zylstra.
Mr. Chairman, I believe I raised, I was one of the people anyway who raised this issue last time, simply from my own review of the charter. And if I recall, that was prior to any petition process being made public, at least. I was not aware of any underway at that time. And if I recall correctly from the minutes, you asked the city attorney to research this a little bit more for us in two regards. One, the relationship between what the charter says and its congruence and conformity with the State Home Rule Act. And also, you asked him for background. As chair, you asked him to look for how many previous petition-initiated amendments have been placed on the ballot. And so maybe we should allow Mr. Koister to respond at this time.
Thank you, Mr. Zylstra. Mr. Koister, are you prepared to discuss these items, or should we defer to another meeting?
Well, I can address them, I guess, to a certain extent. To what extent would the chair want, what questions would the chair have specifically today?
I think the first item would be, I would ask the question that I had raised about whether or not there have been any prior citizen petitions.
Okay, no.
Not including the one that was recently filed since our last meeting.
No. Right. The records for the city reflect there have not been any prior to this one. There have been other amendments, of course, to the charter through the Charter Revision Commission. And as far as the other question goes, regarding the home rule charters, that's actually Chapter 6-12 of South Dakota Codified Law, 612.5 in particular, that does require that neither charter nor ordinance adopted under those sets of laws may set standards and requirements which are lower or less stringent than those imposed by state law. And so from that point of view, both apply. Both the city requirement and the state requirement apply.
I would ask if anyone else has any discussion items on this issue. Hearing none at this time, I think that answers the chair's questions from our prior meeting related to Charter Article 8, being sensitive to the pending citizen petition and leaving open for consideration the possibility of proposals for amendments to Section 8.01D or Charter Article 8 generally. The chair will close our discussion of old business Charter Article 8 at this time. Move to old business item C, power of Charter Revision Commission to propose alternate form of government and how extensive of an amendment would be necessary. This relates to a discussion at the last meeting brought forth by a citizen who asked that the charter of the city of Sioux Falls be amended to adopt a weak mayor form of government, which I believe he conceded would be a fairly substantial change to our charter and changing the form of government which was adopted in 1995 with the original version of our current charter. So I think the question that was raised for consideration by the city attorney's office was whether the Charter Revision Commission possesses the authority under both the charter of the city and the enacting ordinances adopted for the commission by the city of Sioux Falls, by the City Council of Sioux Falls, to make such a change or a proposal for such a change to go on the ballot. Is that correct? I believe it was Mr. Zalstra who raised that question at the last meeting.
Yes, Mr. Chairman. My concern is a little bit of a process, but you have narrowed it down appropriately to the specific legal question. My process question is, it is difficult to rewrite significant parts of a charter without affecting all the charter. And then hearing some who, a presentation that said we should really do a major rewrite of this. My question was, how does that happen? Does this commission have it within its authority to undertake a full rewrite of the city charter? Or would that require some sort of new charter commission, charter writing commission?
Mr. Koistra, are you prepared at this time to address the question of the authority of the Charter Revision Commission to make large-scale changes to the charter up to, or propose them for the ballot, up to and including completely changing the form of government that currently exists in the charter through a proposal to go on the ballot?
Yeah, I'd be happy to address that, again, to a certain extent, barring the extended academic discussion on the procedural component. And actually, the procedural component was addressed somewhat by Mr. Kirby last week as far as how they did it. To the question of to what extent can the Charter Revision Commission change the city's form of government, it really starts, in my opinion, with a foundational understanding of what type of government the city of Sioux Falls has. And by that, I mean, we hear the term home rule charter discussed in a lot of different contexts within the city. And really what you have are two different sections of the code, of South Dakota Code. You have Title VI, which is the home rule charter section of the law, and then you have Title IX, which is municipal corporations. And so, under the municipal corporations code in Title IX, you really have three different forms of government. You've got the aldermanic form of government, you have a commission, city commission, which Sioux Falls used to have, and then you have a city manager form. Okay, but under the home rule charter, it opens up a different avenue of options there, to the extent that when you look at Sioux Falls' current charter, it in effect is this is not a legal term of art, but it's an alderman-ish structure, okay, with the mayor and the council. Okay, so it's when you start talking about form and structure, which are kind of two terms that are used differently throughout the code. What I would say for practical purposes as it relates to this commission is under the aldermanic form of government that we have right now, you can amend that. If you're talking about going from a Title VI to a Title IX municipal corporation, I think at that point you're maybe talking about a different process. Now, I don't want to get too much into the weeds. I don't, for purposes of just the open question, I don't want to get into all of that from, from an advice point of view. But what I would say is when the charter was adopted, there was a model code that was produced. It was actually the 7th version of that, which was dated in 1989, and the drafters relied on that in large part, it appears, to create the charter that we have now. And so within that, there's a lot of latitude as to how to move and how to change certain things. But I think that's also a different discussion. That's a Title VI discussion, if that makes sense. But if you're pulling it out of Title IX, that's probably a separate, pulling it into Title IX, it's probably a separate discussion.
Further discussion? Seeing none, I believe that answers the questions from the commission on that item. We will move to, well, before we move away from old business, I think one item of old business that is not on the agenda, but that I was just going to readdress at this time. At our first meeting, one resident of Sioux Falls, Mr. Mathias, proposed, I believe, 4 specific amendments to the charter. And one of the questions that was raised at our last meeting with Mr. Kirby's presentations and his recommendations is whether or not, in Mr. Mathias's eyes, any of Mr. Kirby's proposals that he specifically made would cover any of the proposals that have been made by Mr. Mathias. If none of those proposals by Mr. Mathias are withdrawn by him, then this commission, in my mind, unless there's disagreement from my fellow commissioners, would need to be considered separately, together with Mr. Kirby's proposals. So we would end up having 6, 7, 8 proposals, some of which may on their face seem to be redundant. So I would again invite Mr. Mathias to come forward at a future meeting if he's not here today, whether as part of public input or otherwise, and comment on whether or not any of Mr. Kirby's proposals would cover any of his proposals, and therefore we would only have to consider Mr. Kirby's. Otherwise, we will consider all of them, even to the extent that they may or may not be redundant. We'll consider them and vote on them as separate items. Further comments on that from the commission? Seeing none, we'll move to item 4, new business. Item A, Charter Article 6, dealing with elections. So the way that we voted to do this at our prior meetings, at our first meeting, excuse me, was the commission would go through the entire charter, in this case, from the end to the beginning, in order, and consider every article of the charter separately, and ask whether any of the commissioners or any members of the public have specific proposals for amendments to each of the articles of the charter. Assuming that every one of our commissioners has, in advance of this meeting, had an opportunity to consider Article 6 and the various subsections, I will go through those, not reading them in detail, not reading them through, but going through each subsection under Article 6 individually to ask whether there is any proposal for amendment or item for discussion or question from any of the members of the commission as to those specific sections under Article 6 first. So Section 6.01 dealing with city elections. We have 3 subsections, A, B, and C: regular elections, registered voter defined, conduct of election. Any questions, items for discussion? Mr. Timian.
Yes. On the formal recommendations, we have 2 recommendations for plurality voting for city council elections. And I don't see where that is addressed anywhere within Article 6, or did I just not read it correctly? Because I think, I guess to me the item is where it comes back to is how do we get to a majority versus plurality? And did that come from the charter or is that in ordinance? And then are people looking at a charter revision to overturn an ordinance that City Council had put in place? Because I was expecting to see that somewhere in the elections, but I haven't seen where it is plurality versus majority as far as runoffs. Or is it in a completely different section?
Mr. Kirby's proposal, and I apologize, I hope I didn't cut you off. Mr. Kirby's proposal on the plurality issue was an amendment to section 2.02B, excuse me, what is currently section 2.02C to the charter, election and terms related specifically to members of the City Council. It is my understanding, however.
I see it in 202.
Okay.
I was expecting an election, so my apologies.
And
Not being an attorney, I don't understand how some of these things work.
No, I think that's more than fine, and I don't want to speak for Mr. Kirby, but my guess as to why he proposed it to go under section 2.02 of the charter is because he wanted his change to apply only to City Council elections and not to any of the other elections that are held in the city of Sioux Falls. Ms. Hayek.
Thank you, Mr. Chair. The only little thing I've noticed here under conduct of elections, and maybe for clarification, which I think we can actually do without even putting it in front, but in section C, it says all elections provided for by the charter shall be conducted by the election authorities established by law. I wonder if we need to qualify law by state law, or do we just leave that? There are a few other spots where we refer to that they shall be established by law, done by law. Do we want to say by state law for our clarification issue, or is that not necessary?
I could be wrong, and I will defer to the city attorney's office, and I'll ask Mr. Koistra to weigh in here in a minute, but I think part of the issue here is that we not only have state laws that apply to some of these election authority issues, we have also adopted some local ordinances. Now, earlier in 6.01C, nominating petition shall conform in all respects to the provisions of South Dakota state law. So my only concern would be that this section may be contemplating municipal local laws that would apply to those election authorities.
And I would just, for a little bit further before our attorney weighs in, as you get down further in that paragraph, it says for the conduct of city elections, for the prevention of fraud, and for the recount of ballots in cases of doubt or fraud, the City Council shall adopt ordinances consistent with, and again, it's law, unqualified. And if you go down further in the next sentence, we also have that word, and that would be a clarification that I would ask for. Thank you.
I would say there again, I don't know that we can specifically limit it just to state law, because I think that there are definitely federal election laws that could potentially apply to some of these municipal election questions. Mr. Zylstra.
Well, I'm just observing that the model charter that they used as their template does use the word laws of the state of, in a place with a blank, and the rest of that suggested article is almost verbatim within our charter. So perhaps there was a reason why they didn't make it state law. Perhaps it was an oversight. But just for information, the model from the League of Cities does indicate subservience, conformity to the general election laws of a state.
Mr. Koistra, is this something we need to let you look at and get back to at the next meeting?
Well, I can certainly do that. A couple comments just off the cuff is that we typically don't presume that there was an oversight in the drafting component. I know you're not suggesting that. The other is that when it comes to the application of the law, and it's part of what Mr. Smith commented on, there may be city law applies that, or federal election law. As a general principle, having the law apply regardless of sort of the level is not generally a concern, or certainly not abhorrent to the fact that it applies law. I mean, you can see there are certain circumstances where it does apply. It references state law specifically, and others where it doesn't when it comes to elections. And of course, we have the chief election official for the city here too, if he has any thoughts. I don't have any concerns about the application of the law to these. When we're discussing what is in effect the foundational document for the city, you know, with amendments not to be made lightly, it would be one where we would want some time to explore that, if that's something that's, you know, that the commission deems, you know, sufficient enough to justify a vote to that effect. So at this point, you know, it's for the commission to decide and vote on. I don't have a lot of concerns when the law applies, and there may be times, and as we sit here, we can't rule out that there may be other levels of law that apply, specifically at the city level, but also at the federal level, that it's not something that's of great concern to me. But
Does that answer the questions on this section? Okay.
It does, and that was just my reference, because I know there's been a lot of questions lately in regard to what we do, what we follow, is it state, is it local? I do have another issue in that particular paragraph, and so when we're done with this topic, I would address that.
Go ahead, Ms. Hayek.
Thank you. When we adopted this charter 25 years ago, the city was a much smaller community. And at that point in time, an individual running for the mayor was required to garner 200 signatures. And as we all know, we've had, I'm not quite sure how many candidates from the last mayoral election, but I am wondering about whether it would make some sense to up that number so that we realize that those people that are seriously looking at the office of mayor are not just on some whim filling a petition. And I'm thinking a percentage of the voters, 2% of the voters in the last election, or something of that nature, which would mean we have only serious candidates. I throw that out, and maybe I'm alone in that issue.
This is just a general question. On that point, if memory serves, and I won't name names, there was a candidate in the last mayoral election, or a potential candidate, who took out petitions but then fell short of the signature requirement, and therefore that name did not appear on the ballot. Is that correct? Okay. So I think
The 200
it is, I think it is working.
Okay.
But I would
Thank
certainly
you.
welcome a
It seems
proposal.
like a very small threshold to me, but there you go.
Further items, discussion, questions under section 6.01, city elections. Seeing none, section 6.02, council districts, adjustment of districts. There are multiple subsections under this one, dealing with number of districts, districting commission, powers and duties of the districting commission, districting plan and criteria, effective enactment. Any items or proposals, discussion, or questions under section 6.02? Ms. Hayek?
And I'm sorry to keep asking questions, but on item 4, I find it interesting that our council positions are non-political. They do not have a political party affiliated with them. And so the appointment, the city council shall appoint a new member enrolled in the same political party. I find that curious, and there may be a reason for it, but allegedly we are not supposed to know the political party of the individual who is sitting in that seat. So I question that, other than, and just throw a little discussion if anyone has thoughts on it.
I think that is on the districting commission. And so that when they're redistricting, as to what is there, when they're redistricting, it could very well be that they're going to know parties. And so that, and I think that has to do with gerrymandering. that if it is all one party, that's why it's a 3-2, and in the, but it's not to the city council itself.
I would, and that, the same requirement actually is in the subsection 1 talking about it, but I think that's absolutely right. I think that even though we try to have our city government be nonpartisan, I think that's the makeup of the districting commission is probably a recognition that we are still going to be impacted by the political party system. So, Mr. Zylstra.
Mr. Chairman, I have had a conversation with the city attorney about section C5. And it's when the commission prepares a plan and you submit it and then it's turned down, and then what do you do next? And I raised the question, and unfortunately it was just this afternoon with Mr. Koistra, so he probably hasn't had time to look at this yet. But as I tried to chart that out, I came to a dead end. And I don't think you're supposed to come to dead ends. A potential dead end would be if the appeals court does not judge it to be valid, but would judge it to be invalid, what do you do next? And I didn't see what happens next. And so, yes, this is a remote possibility, but if there is something missing here that we could rectify before a problem would arise, I think that would be a part of our responsibility. But perhaps Mr. Koistra has a simple answer to this. Perhaps he needs to have time to come back at our next meeting. But I think it is, at least as I read that, I got stuck. And I don't think we want ever the revision process or the redistricting process to get stuck.
Ms. Hayek?
Well, I guess, I don't think it's a stuck. I think it's just that you make a plan, the plan's then approved, a substitute plan is not put in place, then guess what? We're back to square one, and that's where it stays. The people didn't like the plan, they didn't like the changes, they don't want to adopt other ones, and they just leave it. So I don't see it as a dead end.
Further comments? Mr. Zylstra?
Yeah, it had occurred to me that might be a possibility, but again, not being a lawyer, I thought this was saying you had to do redistricting, but I think Commissioner Hayek is saying, well, if you run through the whole process and the redistricting doesn't work, you stick with the districting you got. Is that your understanding of this? Would that make sense according to the city attorney also?
Well, at first blush it would, but I haven't. We just spoke this afternoon. I haven't looked at this. I wouldn't be surprised if that's the case, but I haven't even read it. Well, I've read it, but I haven't researched it.
Well, Mr. Chairman, I don't have a recommendation for a change, and if indeed that does simply toss you back to living with the current districting, then that's acceptable to me.
I think, unless there's further discussion, the chair will ask the city attorney's office to put on the agenda for the next meeting some further discussion. Charter Section 6.02 C5 and the procedure to be followed in the event that a redistricting plan is held to be invalid by the circuit court. Further proposals, discussion, or questions under Section 6.02 of the Charter? Mr. Timian.
On D4, the number of districts which include territory more than one county should be as few as possible. Currently, 2 out of our 5 districts have land in both Minnehaha and Lincoln County. Would that be considered as few as possible, or was it contemplated that there'd be a district that would be south of 57th Street?
In my mind, and again, this is mostly just based on a pure reading, I think that is designed to give flexibility to the redistricting commission to work as hard as they can to make sure that there are as few as possible. But I would defer to our last districting commission and the numbers of the population breakdown and those kinds of things.
I noticed that Central, because it's the southeast and southwest, but Central stops at 57th Street. So Central does not go into Lincoln County. No change proposed.
Further discussion on that item? Seeing none. Are there any further proposals, discussion, or questions under Section 6.02 of the Charter? Seeing none, Section 6.03, Initiative and Referendum. This reserves to the electors of the city the powers of initiative and referendum, made subject to election law of the state of South Dakota, and that will govern the exercise of the powers of initiative and referendum under this charter. Any proposals, discussion, questions under that section of the charter? Seeing none. Move on to our next item under new business, B, Charter Article 5, Financial Procedures. This is a rather lengthy article of the charter. Section 5.01 deals with the fiscal year. Are there any proposals, discussion, or questions? Section 5.01. Seeing none, Section 5.02, Submission of Budget and Budget Message. Are there any proposals, discussion, or questions? Seeing none, Section 5.03, Budget Message, dealing with the mayor's message on the proposed budget for the city of Sioux Falls. Any proposals, discussion, or questions? Seeing none, Section 5.04, Budget. This is a little bit longer section, dealing with the complete financial plan of city funds for the city of Sioux Falls. Any proposals, discussion, or questions? Seeing none, Section 5.05, City Council Action on Budget. Any proposals, discussion, or questions on that? Just looking here, it looks like none of Mr. Kirby's proposals, indeed none of the proposals we've considered to date, have to do with Article 5. Seeing none on Section 5.05, moving on to Section 5.06. This section has been removed.
Yeah.
All right. That was a short discussion. Section 5.07, Amendments after Adoption. Supplemental appropriations, emergency appropriations, reduction of appropriations, transfer of appropriations, limitation and effective date. Any proposals, discussion, or questions, Section 5.07 of the Charter? Seeing none, Section 5.08, Lapse of Appropriations. Proposals, discussion, questions. Seeing none, Section 5.09, Administration of the Budget. Proposals, discussion, questions. Section 5.10, Overspending of Appropriations Prohibited. 5.10, Proposals, discussion, or questions from the Commission. Seeing none, 5.11, Capital Program. Discussion, questions, proposals under Section 5.11. Seeing none, Section 5.12, City Council Action on Capital Program. Proposals, discussion, questions. Mr. Zylstra.
Yes, Mr. Chairman. Again, with my concern of getting stuck. If you look back to 5.05, City Council Action on Budget, item C, the last sentence. If the city council fails to adopt the budget by this date, the budget proposed by the mayor shall go into effect. There is no similar statement in 5.12, and I'm aware this isn't an appropriations section, so perhaps it's not as significant if you run stuck. But I would suggest that it'd be appropriate to add the same sentence at the end of 512B and simply read, if the city council fails to adopt the capital program by this date, the capital program proposed by the mayor shall go into effect.
Discussion, questions on that proposal?
I would at least, Mr. Chairman, perhaps on further reflection, will think better of it, ask that it be put on the list for future discussion.
That was my next question. So we have a proposal from Mr. Zylstra for an amendment to Section 5.12B of the Sioux Falls City Charter to add a final sentence at the end of subparagraph B, similar to the one at the end of Section 5.05C. If the City Council fails to adopt the capital program by, in this case, 30 September of the current fiscal year, the capital program proposed by the mayor shall go into effect. Is that your proposal, Mr. Zylstra?
That is my proposal.
Mr. Chair?
Ms. Hayek?
I'm drawing back some memory of, there's a difference. The city council's action on the budget is a lot more overt, and they have quite a bit more authority in regard to the budget. I think the capital program is generally given to them. I would need some distinction between the two, because I know there is some, and I'm not drawing it up right now, but they aren't equal. It isn't, A equals A. They are two very different, distinct items that are dealt with, and I think we're getting into a little bit of the administrative role too by doing that. So I am curious and would like a little bit more information before we do any action on that.
Mr. Zylstra?
Well, yes. I think one of the differences is it's not an appropriations item. But the other, it does indicate in B that the city council can amend this, so it's not a take it or leave it. So they have the opportunity to amend it to a form that they are willing to adopt after the mayor proposes it. I am not quite sure what as Ms. Hayek is saying, I'm not quite sure what the impact would be of it not being adopted. I know what the impact would be of not having an appropriations item adopted. You couldn't spend the money. What would happen if this simply you went a year without it being adopted? And that's why I would simply at this point want to put it on the agenda for further discussion when we go through that list of proposals. And at that point, we'll probably have the answers to those questions.
So the proposal from Mr. Zylstra is to add this to the list of recommendations. I think we'll go ahead and do that at this time. And the request from Mr. Zylstra and Ms. Hayek would be that the city attorney's office, perhaps the city finance office as well, provide just a brief summary of the process, the differences between the city budget and the capital program, as well as an answer to the question of what would happen under Section 5.12 of the city charter if the city council received the capital program proposal from the mayor and did not adopt it by 30 September of the current fiscal year. We know the answer under 5.05C. The mayor's proposal would go into effect. I'm assuming the answer would be the same under 5.12B, but that would be something that we could consider, whether at the next meeting or when we put this on our agenda. So unless there's a request that this be put on the agenda for the September 11 meeting for final action, then I think the city attorney's office, city finance office has got some time to pull that information together. Ms. Hayek?
And, it's been so many years. I think state law addresses some of this issue. And I may be mistaken, but yeah, I don't know that your concerns are a problem. I mean, I think it's all very, very neat and tidy here, but I would be interested in additional information. Thank you.
And I think the city attorney's office, in their usual exemplary fashion, will be able to advise us on all those points. Anything further? Proposals, discussion, questions, section 5.12 of the charter. Section 5.13, public records. Any proposals, discussion, questions under section 5.13? Seeing none, we're on a roll. We'll move to item C under point 4, new business, Charter Article 4, departments, offices, and agencies. A little bit of a shorter article of the charter, starting with section 4.01, general provisions, creation of departments, direction by mayor. Any proposals, discussion, or questions? Section 4.01. Seeing none. Section 4.02, personnel system, appointments and promotions, civil service system. Any proposals, discussion, questions? Seeing none. Section 4.03, legal officer. Mr. Zylstra.
This is another item that I have discussed with the city attorney. I think I had two questions. I think the answer I received from the city attorney satisfies my first concern. One was, back up. The reason I flagged this item was because we have had a citizen proposal that the city attorney should be a more independent, perhaps independently elected official. This item, it seems to me, is designed as it's written to try to maintain independence of the city attorney. The mayor gets to choose a city attorney with the advice and consent of the council, but the mayor cannot remove the city attorney except with also a majority. And then it says of the 8 members of the council, and the understanding that the city attorney indicated to me is that the mayor cannot vote on that. So it would have to be 5 people other than the mayor who voted to terminate the city attorney. But my other concern is, can just clarity of how independent this is, can the mayor at the end of a first term terminate the city attorney? When it says the consent of a majority of the council is not required for the expiration of the legal officer's term of office that occurs upon the mayor's expiration of term of office. Would that be a 4-year term of office or until the mayor leaves office completely? That is not clear to me. I think it does speak to the independence of the city attorney, depending on what the answer to that is.
Further discussion, questions? Mr. Zylstra, are you asking for the city attorney's office to research the questions that you have just raised?
Well, yes.
Okay.
Yes, thank you.
Ms. Hayek?
Maybe to save a little time, a term of office ends after that term. So if you're elected for a 4-year term, that term ends. You may then be reelected for another term, but I think, you know, it would be for a court of law to decide, but the mayor's 4-year term of office, I believe if the mayor wanted to replace that attorney at the end of one term and then hire a new one, I think it's clear that it says the expiration of the term. And the term is not 8 years, it's a 4-year term. Or is it 5 year? I don't know, it's 4 year, right? So I think it's pretty clear. Maybe not, but.
Mr. Zalstra?
I just want it to be clear because this will affect how I look at a proposal for an independent, putting an independent city attorney on the ballot for, as a potential revision. Because that would lead to less independence, that interpretation. That would be the way I would read it also at first blush. When I asked the city attorney, he thought he maybe needed to think about that a little bit more. But if that is a consensus of the legal minds among us, then that's all the information I need at this time.
Thank you. I would, before we move on, echo Ms. Hayek's reading of the section. I believe that it seems clear that while the mayor cannot fire the city attorney during one of his or her 4-year terms in office, in between 2 duly elected terms, he or she could pick a new city attorney. I would also read it to mean that it is the 8 members of the council besides the mayor who would be voting on the decision of whether or not to allow the city attorney to be terminated. But as part of the discussion on this item that has been proposed by Mr. Mathias at our first meeting, I think that those questions could bear some discussion and comment by the city attorney's office. I'll ask this question. In order to start the ball rolling on some of our proposed amendments to the charter, would we be ready at the September 11 meeting to vote on the proposed recommendation that we amend the charter to make the city attorney position elected, such that we would ask the city attorney's office to have the answers to these questions Mr. Zalstra's brought forward at the September 11 meeting? The chair would entertain a motion to that effect, or we can wait for October, November, or December to decide that question. Seeing none, I think we'll wait. So the city attorney's office has a couple more meetings before we'll move on to that item. Anything further, section 4.03 of the city charter, legal officer? Moving on, section 4.04, planning. Any proposals, discussion, questions under section 4.04? Seeing none, are there any items under Articles 4, 5, and 6 that, because of the speed we moved through them, you didn't have a chance to discuss and that you want to talk about right now? Okay. And as always, any members of the commission are welcome at future meetings under our open discussion item to bring forward proposed or questions, discussion, or proposals under any of the charter sections. At our next meeting, on the agenda will be the final 3 articles of the charter, 1, 2, and 3, a decent amount of which are at issue in some of our proposed revisions from citizens for the commission, and then also in the petition which is pending from the citizens. Moving on, item 5 under our agenda, public input. Is there any member of the public who would like to comment on any of the charter articles we've considered today, any of the recommendations that are on our list of recommendations, or any item related to the Sioux Falls City Charter? All right. Seeing none, I'll move to open discussion from the commission. Any item, Mr. Zalstra?
Thank you, Mr. Chairman, and this is probably close to more of an item of personal privilege, and it reflects on our discussion of 8.01C. In light of some of the things I've read in the media, I would like to point out that, at least as far as this commission is concerned, the city attorney reviewed this at the request of the commission. And also point out that if the city attorney is correct, then no one is changing any rules, but is rather merely clarifying the existing rule under both the city charter, the state constitution, and the home rule law. Something that, as our attorney has pointed out to us, never had to be clarified before, because previously there were no amendments brought forward by initiative. Third point that I'd like to make is, I don't know if it's helpful for anyone else who may have been caught up in the media turmoil over this, but I at least want to make clear that prior to my raising that question at the last meeting, which, as we've said today, took place prior to any announcement regarding any petition drive, I had absolutely no personal awareness that such a drive might be in the offing, and I certainly had no conversation with anyone about my concern. It arose simply from my own personal close reading of the Charter and the Home Rule Act as provided for us. And I think what's important for the Commission to know is that my concern was twofold. First, I hope to avoid the possibility that citizens who wish to petition their government in this way might be misled by confusing or invalid procedures articulated in the Charter as to what process they needed to follow. And second, I hope to avoid the possibility that should an amendment be adopted through following a procedure that does not conform to state law, it would then, under judicial review, be invalidated because it had not been validly placed before the voters. Obviously, and unfortunately, in my opinion, we were too late to avoid that first scenario, but gratefully we have avoided the possibility of the second scenario. And I think this commission now can set about ensuring that the city charter does outline clear, precise, and constitutionally and state law valid procedures for any citizens who seek to exercise their right of initiative in amending the city charter. And so I look forward to our further discussions, but I did want to clarify what had motivated my bringing it up at the last meeting, what had led to the city, to the Charter Revision Commission's request of the city attorney, and where we are in the process at present. Thank you.
From my standpoint, I would ask Mr. Zylstra if he can give me the upcoming lottery numbers, because I think his question at the last meeting was definitely prophetic. I can speak for myself as well that when I asked the question similar to his of whether there had been any citizen petitions before, I had no idea that there was a petition being drafted at that time. So I think his questions were prophetic. And any further discussion under open discussion? Ms. Hayek.
Just one comment I would like to make, because I've been asked by people in the public in regard to, you bring up the petition, and I had been approached by people who said, this will get the charter back where it was when you originally voted on it. And I said, what do you mean? And the understanding was that the mayor was never part of the council. And I said, oh no, go back and read it. And so for anyone out there listening, that charter, the original charter, is available. It's the 1995 one, and nothing of substance in regard to the mayor and the council has changed at all. However, this would be a major change to our form of government if that were to be adopted. So I think it's important for people to understand that there is some misinformation out there, and part of our job is to kind of let them know that it hasn't changed, and this Charter Commission, Revision Commission, has been in place to maintain it be in line, and I think Pauline knows that better than anyone.
Further items under open discussion. Mr. Timian.
I would just like to say thank you to the staff for the outstanding job on the materials they prepare for each meeting, get them out to us. Really appreciate that the three sections of the charter are included with the agenda. Can download it a lot easier than carrying the three-ring binder around. So thank you for the good job.
I would concur, and in a particular way, thank you for the overtime that I know you put in at our last meeting, which ran until just about 6 p.m. So I appreciate that. We will endeavor to make sure that, and that's one thing I should comment on. One of the motivations, I think, at least for me, to vote in favor of Ms. Hayek's motion limiting public input to 3 minutes and kind of clarifying the procedure to get on the agenda in a new business is out of sensitivity to our city staff, making sure that they're not having to work after hours. And that's the other reason why we moved the meeting up to 3:30 instead of our traditional time of 4 p.m., because we anticipated a pretty heavy calendar, and I think that's come to pass this year. So any further items under open discussion? All right, seeing none, the chair would entertain a motion to adjourn.
So moved.
It's been moved by Commissioner Timian. Is there a second? Second. Seconded by Ms. Hayek. All those in favor will vote aye.
Aye.
Aye. Those opposed? Motion carries. We are adjourned.